All right, defendant in the booth, what's your name?
Ashley Fisler.
All right, then this is State of New Jersey versus Ashley Fisler. It is complaint warrant 2026-221-0818. Counsel, your appearances, please.
Good morning, Your Honor. Kylie Finley for the state.
Good morning, Your Honor. Rocco Ciperon on behalf of Ashley Fisler.
All right, is everybody ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
All right, then I'll hear from the state as to probable cause.
Thank you, Your Honor. I would ask that Your Honor mark the complaint as S1, the PSA as S2, and the state's motion filed by AP Morin on March 27th, 2026 as S3. This defendant is charged with 6 counts of aggravated sexual assault, official misconduct, and second-degree endangering the welfare of a child by sexual conduct. The sex acts in this case were reported to have happened in 2021 and 2022, either in her middle school classroom where she taught the victim, or in the defendant's car at the Clusters apartment complex. All occurred in Gloucester County. Specifically, the victim reported at least 2 instances of vaginal intercourse in the defendant's car at the Clusters. He also reported at least 4 separate times that the defendant performed fellatio on him, twice on the same days as the intercourse, and twice in the middle school classroom while he was the defendant's student. The victim's statement in this case was corroborated by the years of text messages between the victim and the defendant. At the time, this defendant was a school teacher at Orchard Valley Middle School, and the state submits that she did have a duty to protect and care for this victim by the nature of her occupation. With regarding probable cause, I would submit.
Mr. Ciperon, anything as to probable cause?
Nothing as the probable cause, Your Honor.
All right, probable cause is nothing more than a well-grounded suspicion that an offense occurred and the defendant was involved in committing the offense. I'll find probable cause has been established. Moving then to the elements of detention. If the state could express the reasons why the eligible defendant will not appear in court, that she would pose a danger to the people or of the community, or that she would attempt to obstruct justice. I'll hear from you.
Thank you, Your Honor. In this case, there are no conditions which the court can reasonably impose on this defendant to assure all 3 prongs of the triad. I would incorporate my statements made in the probable cause portion of this argument here so as not to belabor those specific facts. But, Your Honor, there are attendant circumstances in this case that are not encompassed by the charges, which the court should consider, that go to all 3 prongs of the triad. Your Honor, this was more than just 6 isolated and aberrant acts of sexual abuse against a minor. This was a pattern of 6 years of grooming, manipulation, and abuse by this defendant as a middle school teacher against one of her active and then former students. Your Honor, I did provide a large number of text messages to counsel between the defendant and the victim. Because of the nature of the cell phone, they start in May of 2023 and they continue through January of 2026. There are references in those text messages to FaceTimes and prior conversations, but the actual messages that we have don't go back further than May of 2023 at this time. These text messages show not only the level of the grooming and manipulation by this defendant, but they also corroborate multiple times over the sexual relationship disclosed by this victim, including the specific sexual acts that the victim disclosed to police during his interview. For example, Your Honor, in a text message conversation that occurred on August 9th of 2023, the defendant is reminiscing with the victim about when the victim was in middle school, specifically a time that the victim came to her classroom on her prep period, and the defendant made out with the victim and that they were grinding. This is stated by the victim in his statement to police. He explains that when he was in middle school, he would go to her classroom on her prep period, which was 3rd period. Even all these years later, he remembers the specific period and he recalls this specific incident. She reminisces about the time that they were in the car together and the defendant started to strip while the victim's pants were down. and the victim touching the defendant's inner thigh in her car. Even taking away these specific sexual acts that are corroborated by these text messages, again, this does not stop in 2022 when he goes to high school and graduates 8th grade. These sexual conversations and the sexual endangering of this child continue, such as in late November of 2023, when she talks about the victim and another former male student and asks whether they are sword fighting. Based on the conversation and the context, it appears that she's talking about whether or not they are having their penises touch. In December of 2023, the victim confides in the defendant that he's struggling in school because he's getting erections more frequently in school. And the defendant's response was, quote, "Oh my God, that's fantastic," end quote. She offers that same month to shave the victim's penis and genital area. And just a few months later, in February of 2024, she offers to buy the victim a sex toy. He explains that he's considering getting one, but he's not 18 yet, so he doesn't know that he can buy one. She offers to do that for him. Specifically about the victim's age, there are multiple conversations about the victim's age. There is no mistaking how old this child was at the time of these conversations. For example, during one of the conversations on August 19th, 2023, the victim states that he just wants the defendant to acknowledge that he's changed since he was 12, since he is now 15. The reason he's able to say that, Your Honor, is because this defendant met him when he was 12 years old as her 7th grade student. She knows how much he's changed because her communication with him has never stopped. There's also a discussion specifically on May 26th, 2023, where the defendant has recommended a movie to the victim. And in that movie, one of the characters is talking to their genitals. And the victim, in a joking way, asks if she's ever talked to her vagina. And she explains that the first time she caught the victim's eyes, she told her vagina, quote, "No," end quote, because, quote, "you were my student in my class." Your Honor, the damage done here was not only encompassed by the sexual abuse, but the pattern of manipulation that caused mental and emotional damage to this child. The victim tells the defendant that she was his first female non-friend interaction, and he talks to her about his mental health struggles and how he doesn't know how to deal with what he's feeling as a result of her abuse. She even admits that she put him in positions that she shouldn't have and says, quote, "I feel like I forced you to grow up abnormally quick." That was on August 10th of 2023 when he was 15 years old. The victim also tells the defendant how, even as he's coming to an age where he wants to have sexual acts and sexual contact with girls his own age, he's struggling because he says in November, he doesn't even want to have sex with another girl because he knows he'll just end up thinking about the defendant. And the defendant's response to that is not to, quote, "call her Ashley in bed," end quote. On June 3rd of 2024, he sends a very long text to the defendant explaining all these mental health struggles that he's suffering. And in response, the defendant admits that she hurt him countless times and says, quote, "I take the blame for all of this." And Judge, just to really, I can't exemplify the damage done to this child more than he already has in his own words. On January 20th of 2025, the victim told the defendant, quote, "I've had to try really hard to rebuild the things you broke inside of me. You destroyed things inside of me. You stripped me of my innocence." Your Honor, these charges do not encompass any type of child sexual abuse material offenses or sending obscenity to minors, but these are circumstances that the state would ask Your Honor to consider. They are not encompassed within the actual complaint, but they are circumstances that Your Honor is able to consider. For example, on June 1st of 2023, she asks the victim to send pictures of himself in his boxers and says she is disappointed when he didn't. Now, because of the way that these text messages are, because they're some time ago, the thumbnails in the text message export from the extraction are blank. So we can't actually see the embedded images in these text messages, but we can see when an image is being sent and we can see the context. So for example, at one point, the victim sends an image to the defendant that can't be seen in that extraction, but based on the context of the subsequent messages and the defendant's responses, it seems to have been a picture of the victim's penis. He would have been underage at the time. The defendant also talks about sending this victim pictures from a stage while they were on a field trip, and they talk about when she sent him pictures of her in just panties. The victim also references in July of 2024 sending sexual pictures to the defendant in the past. And on February 25th of 2024, the victim would have been 16 at the time. The defendant says she wants to see his penis after she recommended that he trim his pubic hair. She specifically clarifies she wants a, quote, before and after, end quote. Again, based on the context of these text messages, because we cannot see the actual image that was sent, the victim does send a picture of his erect penis. And the reason I say this is because the defendant's response is, quote, "You got hard just thinking about me," end quote. The conversation continued into the next day when the victim said, "I took pictures for you." Your Honor, even though it is not charged, even though we do not have these images, if the victim in fact took photographs of his penis for the defendant after she directed him to do so, that is manufacturing child sexual abuse material, and it is a circumstance that Your Honor should consider, because that circumstance shows not only the damage done by this defendant, but the danger that she poses to the community. With regard to the weight of the evidence in this case, the weight of the evidence is extremely strong. As I stated before, the text message in this case corroborate the victim's statement to police about the sexual abuse. For example, in December of 2024, the defendant and the victim talk about how they used to hang out in the defendant's car. As I stated during the probable cause portion, the victim said that they actually would go for drives and then she would drive them to the cluster's apartment complex and they would have sex in her car. There are also multiple conversations where the defendant reminisces about the sexual abuse committed against the victim, and she tells him that he was the only student that she ever did anything with. There are two other points that go directly to the weight of the evidence in this case, and that is the defendant's lies in her statement to police and the alleged delay in disclosing. I'm going to address her statement first. So the defendant in this case did give a post-Miranda statement to police, and she initially denied that she knew she was texting the victim. Her original statement was that she was texting a grown man from Ohio that she had met on the internet that coincidentally had the same name as her former student. Ultimately, detectives confronted her with some of the text messages that they already had from the victim's phone, and she admitted, ultimately, that at some point in the years-long conversations, she knew it was him. But, Your Honor, based on the context of these conversations, she knew all along. She claims she doesn't save phone numbers and she wouldn't have known who she was texting, but she initiates the conversations multiple times. She texts, "Good luck on your first day," on the first day of school in 2023 and 2024 for that school year, and she wishes him good luck on his driving test on his 17th birthday. There are many discussions throughout these text messages about school and the victim being in school, specific teachers that she knows and that he then has. And in July of 2024, the defendant even says to him, quote, you're 5 years from 21, showing that she knows who she's talking to and that he is still 16. She also tells him, and this was confronted, the detectives confronted her about this in her statement. She says in the text messages that when she was cleaning out her classroom after leaving her teaching job, she was thinking about him. And these conversations around the classroom, the defendant was confronted with in her statement to police. She admits the guy she allegedly was talking to that was an adult from Ohio never came to her classroom, was never in her classroom. There would be no reason they would talk about that. And Your Honor, just to clarify, the reason she left her teaching job, what she characterized it in her interview was that she blurred the lines with another student. Regarding the delay here, there is no significant delay. While the sexual contact stopped in 2022, the sexual conversations did not. And additionally, the last contact and communication was initiated by the defendant on January 3rd, 2026. The victim reported these acts to the police 10 days later, January 13th. That is not a significant delay for someone who was abused, groomed, and manipulated for 6 years. Also, based on the text messages, they were still seeing each other in person in 2024 and 2025. They just weren't having sexual contact. The last time seeing each other based on the text messages was July 7th, 2025. They saw each other in public. It seems to have been a fleeting sight, but that doesn't mean that they weren't seeing each other. Additionally, as is clear in the text messages, he's still seeing her friends on a regular basis because they're his teachers. Just to talk about the sexual conversations that occurred, because again, while the contact stopped in 2022 when he stopped being her student, the conversations did not. Throughout 2023 and 2024, she sends him multiple explicit movie recommendations, and she talks with him about how that makes him hard. I'm going to give Your Honor just a snippet of these conversations to keep this brief. There are over 7,500 pages of text messages between the defendant and the victim. So I can't go through them all here for purposes of time. So I'm just going to give you a snippet from August of 2023 through January of 2024, because the victim turned 16 years old in 2024. August 9th of 2023, she asks him to come hold her at her home and says she left the door unlocked. Also that month, the victim bragged to the defendant about having sex with an 11th grader at a party. He would have been going into his 10th grade year. The defendant's response to that was, quote, "I wish it was me," end quote. The victim then clarified upon questioning by the defendant that he was thinking about the defendant while he was having sex with the girl, and he also wished it was her. The defendant asked if the victim was going to have sex with her again and asked for specific details, such as whether the girl had put the defendant's penis inside of her vagina, then saying, quote, "Watching your face relax and simultaneously tense up at the same time is my favorite when I slide you inside of me," end quote. Later that day, the victim said that the girl had reached out to him and she never felt like she did during sex with the victim. And so the defendant said, "I clearly taught you very well." She then asked point blank, "How did you make her come?" And when the victim described what he and the girl did, the defendant asked, quote, "How come I never got eaten out? Now I'm sad," end quote. And she said that she was jealous that it wasn't her. And then asked for more specifics, such as, quote, "What did you do with your tongue that she liked so much?" Your Honor, these are not just sexual conversations which are endangering the welfare of this child, but this is also showing the manipulation of this defendant, that the victim can't even have what most people would deem a normal sexual encounter with an age-appropriate person without her turning it into something about her. She is bringing up their prior sexual acts. She's wanting all of the details, and she's talking to him about how it's making her jealous and sad. In November of 2023, she asked the victim if he touches himself. And that same month, a couple weeks later, there are texts about the victim, how he used to put his hands between her legs where it was warm, and the defendant orgasming. Again, the defendant is not currently charged with having the victim digitally penetrate her, but these are circumstances that have come out in the course of this investigation, which is ongoing. They discuss how the defendant used to have the victim penetrate her vagina while she drove him around the school and how good of a distracted driver she is. They also talk about how the defendant taught the victim, quote, "where the clit is and how to find a G-spot." Your Honor, finally, for this portion of the text messages, in January of 2024, there was a conversation where the defendant recommended what they call porny movies to the victim. She directs him to watch these, and throughout the course of about 2 hours, they talk about how it's arousing him, how he is erect. And finally, when he finishes this movie, he asks her in the text messages if he can masturbate and finish. The defendant's response was, quote, "I just wanted to hear you say it. The answer is yes. Come for me now." End quote. Like I said, Your Honor, this is not isolated and aberrant. This is a continuous course of conduct that occurred over the course of 6 years. She was his middle school teacher when it started. Ultimately, she left that job. But even when they weren't seeing each other regularly, her sexual abuse of the victim did not stop. With regard to the risk of flight in particular, State v. Steele and State v. Pinheiro both state that exposure to even a 10-year sentence creates a risk of flight. Here, she is facing 20 years on each of the aggravated sexual assault charges alone, along with the second-degree charges up to 10 years for the endangering and official misconduct, Megan's Law, parole supervision for life, and an Avenel evaluation. While the state admits she is a homeowner and she does have ties with community, it seems, based on the text messages, that her family and friends are local. Those facts are not sufficient to overcome the risk of flight here. It is well established in common law that there is a risk when the exposure increases. Additionally, she admittedly does lack a criminal history. That doesn't mean there's a lack of criminal activity. This conduct goes back to the actual sexual contact goes back to 2021. The beginning of the grooming goes back to 2020. She was not law-abiding for the last 6 years. She just didn't get caught. Your Honor, just to head off any Mercedes arguments, Mercedes does not apply here. At Penn site 155, Mercedes held that, quote, "A recommendation against a defendant's pretrial release that is based only on the type of offense charged cannot justify detention by itself." I am not asking, Your Honor, to only consider the type of offenses charged here. I am asking, Your Honor, to consider each of the 7 factors outlined by the law: the nature and circumstances of the offense charged, weight of the evidence, the history and characteristics of the defendant, the risk of obstruction, the risk of danger to any person or the community, and the recommendation of no release. There is no case law, statute, or rule that anyone will be able to find that says the court cannot consider specifically the nature and circumstances of the offense and the recommendation of no release. In fact, the law requires that Your Honor do consider those, and you can give them whatever weight you deem appropriate. I am not asking you to violate Mercedes, and you would not have to do so in order to detain this defendant. Your Honor, with regard to the risk of obstruction here, I have provided Chambers with a proposed sex offense restraining order. I would ask that Your Honor order that and sign it regardless of your decision. But there are multiple lay witnesses in this case who are not victims and would not be protected under a sex offense restraining order. There is also, as evidenced in the course of this investigation, years of hiding the evidence of the sexual abuse of her student. And at least one other family reported inappropriate communications to the police from the defendant to another child who was her student at the time. And in September of 2024, the victim told the defendant that another student, a third child, was telling people that a teacher named Mrs. Fisler from middle school sent him bikini pictures. So, Your Honor, there is a risk of obstruction. This investigation is ongoing. If Your Honor were to release her, there are no conditions which you could set that could mitigate or eliminate that obstruction risk. And finally, Your Honor, with regard to the danger to the community and any individual, the extent of the pursuit by this defendant bespeaks a heightened risk, even that over and above those typically charged with these types of crimes. For example, the victim, as stated by the victim, they used to have sex in her car at the cluster's apartment. That's a public place. They were in a parking lot. He recalls a time where the defendant performed fellatio on him as well when other people were in the room. And the defendant says in the text messages, quote, "I did do that," and quote, "I was brave." She even then clarifies further, saying there were literally people right there. Whether they were in public or there were other people in the room, her criminality could not be deterred. Additionally, the victim tried multiple times to break off this relationship and communication, but the defendant pulled him and manipulated him right back in. For example, in October of 2024, the victim told her that he needed to disappear for a while regarding communication with her because he was struggling so much with his mental health. She then responds saying that he should check in at least weekly with her, but suggested checking in daily. And additionally, in January of 2025, again, these communications from the defendant did not stop until, well, really, we know they didn't stop until February, but before the disclosure of the victim, the defendant's communications did not stop until 10 days before the disclosure, January 3rd. But on January 20th, 2025, the victim sent, and he could not have been more clear, Your Honor, quote, "I don't want you in my life anymore. As I'm getting older and I look back on our situation with a better understanding of the world, I can't help but to see you as manipulative and selfish." That's a quote from the victim's text messages. And even after that message from the victim, the defendant continued initiating normal, everyday conversations. She texted him the next day, and the next day, and the next day, and the next day. She did not stop texting him until 8 days after he said this. And then on the 9th day, she triple texted him without a response. She texted again on the 30th, 10 days after the victim said, "I don't want you in my life anymore," and said that he was starting to realize her manipulation. She would not let him go. Your Honor, in November of 2023, the defendant shows the lack of remorse that she has. The defendant sends the victim a photo. Again, we can't see what it is. But the victim's response is jokingly, clearly from the context, it's joking. He says, quote, "Whoa, are you trying to rape me?" And the defendant's response is, and to send another photo, to which the victim is clearly confused and responds, "When did you rape me?" That's because he is a child, Judge. He is 15 at the time of this conversation and has been groomed by his teacher since he was 12. He has no idea what she did to him was wrong. She is joking about whether or not she raped her student. This shows an absolute lack of remorse that increases her risk to the community. Your Honor, finally, on December 7th of 2023, they are again reminiscing about the sexual abuse that this defendant committed. And as she frequently does, she wants the victim to talk about it. She asks for more detail. She says, "Whatever do you mean?" And the victim's response was, quote, "You grabbed it, rubbed your juicy on it, stared me in my eyes and looked down and bit your lip, licked my ear, sucked a lollipop, put it in your mouth, rubbed up and down on it with your hand, rubbed the inside of my thigh, kissed me, flashed me, grind on me when I picked you up, licked the outside of my pants, put it in." The defendant's response was that she apologizes for nothing, in all caps. There's no remorse here. She admits in the text messages that she was sexually attracted to the victim when he was 13 and 14 years old, but she apologizes for nothing. She doesn't apologize for the fact that the victim lost years of his life to her grooming, manipulation, and abuse. There is nothing that can protect the community from this defendant or protect the victim. On January 20th of 2025, the victim said, quote, "I've had to try really hard to rebuild the things you broke inside of me. You destroyed things inside of me. You stripped me of my innocence." But she apologizes for nothing. There are no conditions which Your Honor can reasonably place on this defendant to assure that she does not strip another child of their innocence or continue to manipulate the victim. While she does score a 1-1, the PSA appropriately recommends no release. There are no conditions here, Your Honor. Ultimately, the crux of this case can be summed up in the victim's own words. He writes, quote, "I didn't deserve what you did to me when I was 12 to 14, and there's no excuse for it. I look at old pictures or videos of myself, and I was so young, Ashley." There is no excuse for this defendant's behavior. And yet, she apologizes for nothing. So for all of those reasons, Your Honor, I ask that you follow the recommendation of the PSA and detain this defendant pre-trial. Thank you.
Mr. Ciparone?
Thank you, Your Honor. And I don't mean this in a disparaging way, but the prosecutor speaks with a forked tongue here. She tells you that Mercedes does not apply, but then tells you that the recommendation of the PSA is appropriate. The PSA recommends no release based solely on the nature of the charges. That recommendation is exactly adverse to Mercedes. So the court cannot and should not put any stock in the recommendation of the PSA because it is solely based on the nature of the charges, and Mercedes does apply in that scenario. I understand that Ms. Finley's arguments go beyond that, but the PSA itself, the recommendation flies in the face of Mercedes. So Mercedes does apply here in that regard. So I've heard Ms. Finley talk about the argument that the triad, as she calls it, cannot be protected here. I have not heard her dismiss any other conditions. And as the court knows, and I know the court is aware of this, of course, that the court's obligation is to impose the least restrictive conditions that will reasonably assure the appearance, the safety of the community, and the integrity of the process, or for lack of a better term, no obstruction. And if there's any combination of conditions that would assure that, the court cannot and here should not detain Ms. Fisler. Ms. Finley went through, and unfortunately, you know, there are, when I say unfortunately, I mean, there are 7,500 pages of text that I didn't get, no fault of the states, right? That's the nature of the beast here. Late Monday night, I spent pretty much all day yesterday reviewing those, and I can say to the court that the selective, salacious texts that were recited by the prosecution lack context. Obviously, I'm not here to try the case at this stage, but I can tell the court that many of those texts that were cited are out of context and without full airing of what preceded and came after it. But even accepting what the state says about those texts, they go merely to the weight of the evidence, not the risk of flight, danger, or obstruction. It's a factor the court can consider, but it is one among many. And all of the other factors the court has to consider weigh heavily in favor of release and certainly denial of the state's motion. One of the things the state tries to do is bootstrap this January 2026 complaint into a recent complaint by saying, well, the last communication was in early January, and 10 days later, this individual reported it to the police. The text, as I understand it, in January of 2026 was happy birthday. This conduct allegedly happened in 2021. No matter how the state wishes to, for lack of a better term, fudge that, this is approximately a 5-year delayed complaint to the police from this conduct. And that's a factor the court has to consider. The state talks about 2 witnesses that were interviewed. These are not witnesses in the sense of witnesses to the alleged crimes, Judge. These are people that the complainant allegedly told that some of these instances occurred. And I can tell the court I've listened to the interviews, and there are inconsistencies between at least what one of those quote unquote witnesses reports about what he was told by the complainant and what the complainant says occurred, is in particular with respect to details. Again, I'm not going to litigate or try the case here, but the court has to be aware of that context as well. What I did not hear the prosecution say is that there are any contemporaneous texts, images, evidence back in 2021 that reveal this alleged conduct. These are texts, the ones that were provided to me, and I believe, and I talked to Ms. Finley about this, the state is in possession of no texts, communications of any nature that predate 2023. And although it was a creative characterization for the prosecutor to say to the court, because of the nature of the phone, we don't have images, we only know that images were sent, and she tries to make inferences about what images were. The reality is that's a limitation in the state's evidence. That goes to the weight of the evidence. So this is not a rock solid, clear-cut case by the prosecution. What the state also left out, and I'm sorry if I'm jumping around factually here, Judge, I'm trying to do some rebuttal, and then I'll go back into a more organized presentation. But the state also talks about Ms. Fisler's statement to the police. That statement occurred on March 19th of 2026. The state left out that she voluntarily went to the police station when requested to do so, that she was Mirandized, that she had no counsel, that she waived her right to counsel, that she waived her right not to speak to the police, and she gave a full statement and answered all their questions. The state leaves out that Ms. Fisler, at the end of that, agreed to take a polygraph test, and they scheduled a day for her to come back and take the polygraph test. She got a call from the police later to come down and take the polygraph test on the agreed date, at which time she voluntarily went to the police and instead of being given a polygraph was arrested. So Ms. Fisler was cooperative with the police, showed up twice, even agreed to take a polygraph, but wasn't even given that opportunity. And all of that, Judge, was without counsel. I was not engaged until after she was arrested. She willingly interacted with the police. And the prosecutor left out that she denied in her interview any physical sexual contact with this alleged complainant. And she was consistent about that throughout. Even notwithstanding the prosecutor's characterizations that she lied about other things, that's a normal progression where people are nervous, Judge. They're hit, at the spur of the moment, and that's intentional by police, of course, with allegations. And she did address those allegations head on and told them, no, I never had sexual conduct. And all of the texts, when I look at them, can be viewed as sexting in 2023. Whether or not that's a different crime will be aired out, but there is no direct evidence whatsoever of any sexual contact back in 2021 regarding this deferred complaint. And there are substantial weaknesses in the state's case, notwithstanding the salacious nature of the text referred to by the prosecutor. And the court, should not be swayed by those things. Let's focus on the key things the court does have to apply here. Let's look at Ms. Fisler's background, the PSA, and what we know about her. She has no prior convictions, no prior arrests. She's age 36. She's essentially been a lifelong resident of New Jersey, in particular, Southern New Jersey. I think she moved here when she was 4 or 5 years old with her family. All of her family, her parents, her uncles, her aunts, her cousins, her extended family, her grandmother who's in her 90s, all live within a 5 or 10 mile radius of where she does. She's married. She owns a home. She is gainfully employed in her family's arborist business, and she has an online clothing business. She has not been a teacher since 2023. And although Ms. Finley tried to create an inference that she left that employment because of she characterizes it inappropriate conduct, and that she said that in her statement, what Ms. Finley, again, creatively left out is that in her statement, Ms. Fisler told the police that the reason she left was because a female student had a hickey on her neck. She asked Ms. Fisler to buy her cover-up makeup so that she wouldn't get in trouble from her parents for covering up the hickey. Ms. Fisler did that, and she said, I blurred a line, and I decided to leave teaching to pursue other things. That's the inappropriate conduct that she left teaching, not just for that reason, Judge, but that's the conduct to which Ms. Finley was referring, and she left that out to create an unfair inference in Your Honor's mind as to the context of that. Because, frankly, the state has to reach here in order to be able to try to convince the court that Ms. Fisler is a danger to the community. She's no longer a teacher. This is not a person who's considered some kind of serial child molester, for lack of a better term. Ms. Finley references a report regarding another prior student. I reviewed that report and the texts that were attached to it. And and I don't think the court should consider them at all, but nonetheless, I looked at those texts. There was not one reference to sex, sexting, or sexual conduct in any of those texts regarding that other student. Nothing at all. So again, that's a big zero. And Ms. Finley left that very vague. Whether it was intentional or not, I don't know. But the point is, I looked at those texts and I'm referring that to the court. And I'm sure if I'm wrong, Ms. Finley would correct me, but I know I'm not wrong there, Judge. There are no pending charges. Ms. Fisler is 36 years old. There's a 5-year gap from the time of the conduct to the time of the alleged report. And Ms. Finley leaves out, I'm sorry, I keep juxtaposing the names, Judge, but Ms. Finley leaves out also that the complainant engaged or had a lawyer prior to going to the police. So before going to the police, he goes to a lawyer, talks about his options, and there's a potential monetary motive here, Judge. And only then does he go to the police. And these later texts where he's talking about the damage you've done to me, et cetera, there's a fair inference that they were counseled. Because when you look at the history of the texts, at least the way he's texting, and I understand the age at the time of the texting, we're talking about probably around 16 at the time these texts were going back and forth from 2023 forward. He's not texting like a kid. I've seen in my business, obviously, as we all have texts among adults that are sexting, and his texts are as graphic and direct as any I've seen from any adult. I am not saying that he's not the age he is, but this is not a babe in the woods scenario that Ms. Finley's creating from a risk and a danger perspective. The reality is the court can craft a combination of conditions. There are no DV restraining orders against her. She's never had any police interaction in the past. As I talked about, she was, voluntarily engaged with the police. And when the court is faced with a near lifelong, or for all intents and purposes, a lifelong New Jersey resident who's employed, doesn't have interaction with students, she's not a teacher anymore, she works in completely different fields, no criminal history, no failures to appear, and very unprompt complaint, the court can craft conditions. The court and Ms. Finley says the court won't find any case law to support the position that Your Honor can't consider the charges. I'm not telling Your Honor you can't consider the charges, but for example, State versus SN 231 NJ 497, expressly the Supreme Court reversed the detention where the court overemphasized the severity of the charges and disregarded the low risk and the strong ties to the community. And that's exactly the situation here. Ms. Fisler has ties to the community that equal and rival any other ties to the community that any defendant has. The prosecutor relies on the generic nature of the penalties when she talks about risk of flight. She only points to the court that the risk of flight that any defendant poses because of the generic nature of the potential penalties. That's true in any case, Judge. She has not pointed to one single factor that suggests that Ms. Finley is a risk of flight beyond the generic that applies to every defendant, including every defendant the court ever releases on bail. Secondly, as to obstruction, she hasn't pointed to a single fact. She says there were attempts to hide this relationship. She didn't tell the court one single attempt to hide the relationship. And I read 7,500 pages of texts to the contrary, Judge. Obviously, there were no attempts to hide things because the state has what it has in terms of evidence, strong, weak, or neutral. So that's a big zero because Ms. Finley did not point the court to one example that is substantial in that regard. So there's no risk of obstruction. The Soro order, to which I have no objection, by the way, of course, Your Honor, would completely preclude any contact with the complainant or his family. One of the two alleged quote unquote witnesses, and I've described the context of those, Judge, one lives out of state in North Carolina. The other is the roommate of the complainant. And of course, the Soro would bar Ms. Fisler from contact there. And of course, I have no objection that the court should order no contact with any known witnesses or identified witnesses. So she resides with her husband. She's lifelong, Judge. The state's evidence leaves something to be desired. It's contextual, selected, salacious texts that will be challenged. that when you look at the context, all of the evidence supports that there is a combination of conditions that will minimize risk of flight, minimize any alleged danger. There is not this broad-based danger to the community, and certainly there's no indication of obstruction. I'd submit that level 2 monitoring, Your Honor, with the restrictions on contact with witnesses, and I don't think it's necessary, but if the court wanted to add no unsupervised contact with minors, that's fine. I don't think it's a necessary condition, but if that makes the court more comfortable as a condition, I don't have an objection to that. But there is a combination of conditions that would meet the triad. The state has not met its burden by clear and convincing evidence to convince the court otherwise. I'm happy to answer any questions from the court, but I know the court's been through this and knows the standard very well many times.
Ms. Finley, anything else?
Just extremely briefly with regard to obstruction, counsel points out that I did not make any specific notes. Judge, there are texts from this defendant saying that she was blocking the victim's number when her husband had to use her phone. She knew what she was doing was wrong, and she was actively trying to hide that from the person that she was living with and married to. Somehow, there was no indication over the course of years, and as both of us have said, 7,500 pages of text messages that she was texting this child, but she explains that that's because she's blocking his number. And she tells police that she deletes text message threads and text message conversations out of her phone whenever she's done with them because she frequently has affairs. So she's used to deleting those messages and hiding the evidence. So, Your Honor, there is specific evidence of obstruction here. I would just rely on my previous arguments with regard to the other two prongs of the triad.
And Judge, obviously that's not obstruction. That's hiding affairs from your husband. That's not obstructing justice. They're two completely different things. Even if that's true, Judge, even if those texts were not hyperbole, that's not obstruction. Thank you, Your Honor.
Have there been any previous postponements of this case in terms of this proceeding?
No, Your Honor.
And
Not to my knowledge.
She was arrested on Thursday of last week. We had an appearance on Friday and today's hearing.
Let me ask this another way. Mr. Sipper, are you available tomorrow morning?
Can you give me a moment, Judge, to go off screen
Absolutely.
and check? Thank you. I can be, Your Honor.
You cited a case earlier. You said 231 New Jersey. I think you said 497. Did I write that down correctly? State versus initials?
Yes, state versus S is in Sam, N is in Nancy.
That's 231 New Jersey, 497?
Correct.
All right. I'm going to carry this matter to tomorrow morning, 9 a.m. It'll be the first thing I do. I'm going to decide it. I'd like to put something in writing, I think, to assist the court in balancing all of the various factors that go along with a situation where a defendant's charged with a first-degree offense, where the state has corroborating evidence of what would really be, if this was just a 5-year-old allegation and there were no corroborating evidence, it would be a 5-year-old allegation. There'd be a presumption of release. Defendant scores a 1-1. There's still a no release recommended. I do want to consider whatever it is the Supreme Court said at 231 New Jersey, 497, which is not immediately top of mind. I'm sure I read it once, but I'd like to read it again. So I'm going to bring you both back with the defendant tomorrow morning at 9. I'd like it to be scheduled first if we can, Tatiana, and I'll render a decision at that time. Because a decision to detain or not detain sets the tone for the entire proceeding, where the defendant's presumed innocent and the defendant has a presumption of release. It's not to say that other people this morning aren't going to get detained. They probably will. But those are people with long records. But I want to give this careful consideration. because a decision one way or the other sets the tone for the entire case. Ms. Finley, are you available tomorrow as well? I should have asked you too, because you're a prosecutor, so you're probably available tomorrow morning.
Either Chief Gutierrez or I will be online, depending on our individual schedules. But Your Honor, I would ask the sex offense restraining order be entered even without.
I already
Your
signed
Honor.
it. I'll ask my law clerk to upload it and send it to the appropriate parties today. There's been no objection by the defense to the signing of the SORO. The victim's initials are GG.
Yes, Your Honor.
All right, so it looks like the SORO therefore is correct. I signed it effective today, April 1st. The defendant will be prohibited from Gigi's house, his mother's house, a couple of different addresses which I'm not going to place on the record.
Thank you.
Because the alleged victims in this case have a right to privacy, as does the defendant. So I'll decide this case tomorrow morning at 9.
I appreciate the pause, Your Honor, as you know, not the least of which detention hampers or slows down the progress of the ability to prepare the defense, right? I mean, there's a lot of electronic data here that has to be reviewed of my client. It's cumbersome and it's difficult, frankly. So I appreciate Your Honor's pause there.
All right, I'll see you both tomorrow at 9 a.m.
Thank you, Your Honor.
Thank you, Your
Have a good
Honor.
day.